You ever stop to think about the invisible legal fences that protect all your stuff? I mean everything, from the ground under your feet to the phone in your hand. Turns out, the law has a whole set of rules designed to keep other people's hands and feet and even their data off your property. Today we're going to dive right into this really fascinating area of law, and we'll start with a simple question.
Yeah, it sounds a bit like a riddle, doesn't it? On one hand, you have a simple, muddy footprint on your grass. On the other, a malicious flood of emails designed to crash your company's server. Worlds apart, you'd think. But in the eyes of the law, they might be surprisingly similar. And by the end of this, you'll know exactly why.
So that connection between a footprint and an email, well, it all comes down to a fundamental legal idea called a tort. At their core, both of these actions are potential civil wrongs. They're an interference with your basic right to be left alone and to enjoy your property in peace.
Okay, so what exactly is a tort anyway? The simplest way to think about it is that it's a civil wrong. It's the law's way of saying, hey, if you wrongfully cause harm to someone, you can be held responsible for it in civil court. Now, this is different from a criminal wrong. We're not talking about jail time here. We're talking about disputes between people, usually settled with money, to try and make the injured person whole again.
Now, for the kinds of torts we're talking about today, the intentional ones, the law has a pretty clear three-part recipe. First, you need an act, a voluntary movement. Second, you need intent, and this one is a little trickier than it sounds. We'll get to it in a second. And third, causation. The act actually has to be a major factor in causing the harm. Seems straightforward, but that second ingredient, intent, is absolutely crucial. All right, let's break down intent, because this is where the law gets really interesting. It's not just about wanting to cause harm. Specific intent is easy. That's when your goal is to make something happen. But general intent is way more subtle. It means you knew with substantial certainty that a result would happen, even if you weren't actively trying to cause it. The classic example is pulling a chair out from under someone as a joke. You might not want them to get hurt, but you know it's substantial certainty they're gonna hit the floor. In the eyes of the law, yep, that's intent.
All right, so with those ideas in our back pocket, let's apply them to our first and maybe the most ancient property tort out there, trespass to land. This is the original get off my lawn law, and it protects your right to your real property.
The definition looks super simple: an intentional physical invasion. You know, you walk onto your neighbor's land without their permission. But trust me, those two words, intentional and physical, are doing a ton of legal work here, and the law has stretched them in some pretty wild ways.
So here's what's really key. First, notice the intent you need is only the intent to enter the land, not the intent to trespass. So even if you honestly thought a piece of property was yours and you walked on it, you still intended to be on that specific patch of ground. That's a trespass. And this is a big one. No actual damage has to be done. Just the invasion of your right to have your own space is considered the harm.
And this is just a brilliant example of how the law adapts. What really counts as a physical invasion? Well, a court actually found that invisible microscopic particles from a factory that landed on someone's property could be a trespass. This just goes to show that an invasion doesn't have to be a person or some big object. It can be something you can't even see, and that has huge implications for things like pollution and other modern problems.
Okay, so we've covered land. Now let's move on to your personal property. Your car, your computer, your backpack. The old-timey legal word for all this stuff is chattels. And yep, the law has a specific tort to protect you from even minor interference with your things.
The two magic words here are minor interference. We're not talking about theft or total destruction just yet. This is about someone meddling with your property in a way that causes some kind of harm, even if it's just for a little while. So to prove a trespass to chattels, you have to show that the other person intended to mess with your item, that they actually did interfere with it, and here's a key difference from trespass to land, that some kind of harm happened. Either the item got damaged, or you just couldn't use it for a while. And this brings us right back to our opening riddle. Remember the footprint and the spam attack? Here's the connection. A court decided that a computer system is chattel. It's personal property, so intentionally flooding it with so much data that it can't function is a kind of physical interference that causes harm. A spam email attack literally becomes a digital trespass.
So, what happens when the interference with your property isn't minor? What if it's so serious that the thing is basically destroyed or stolen for good? That's when we level up from trespass to a much more serious tort, conversion. The easiest way to think of this is as the law's version of the you break it, you buy it rule, but on a much bigger scale.
The absolute keyword here is significant. We are talking about an interference so major that a court will essentially force a sale. The person who committed the tort has to pay you the item's full value, and then they get to keep whatever's left of it. It's the law saying the interference was so complete, it was as if they just bought it from you.
The core idea of conversion is this concept of dominion. It just means you're treating someone else's property as if you're the true owner. You're not just borrowing it or scratching it, you're acting in a way that completely ignores the real owner's rights, like selling their stuff, destroying it, or just flat out refusing to give it back.
Okay, this is probably the most common point of confusion. Both of these torts deal with messing with someone's personal property. So, when is it just a trespass to chattels, and when does it tip over into the much more serious tort of conversion? Let's just break it down.
Looking at them side by side makes it pretty clear. It all comes down to the degree of interference. Let's use a car as an example. Someone keys your car door. That's a minor interference. Annoying for sure, but you can get it fixed. That's a trespass to chattels, and the remedy is the cost of that repair. But what if someone steals your car and sells it? That is exercising substantial dominion over it. That's conversion. The law matches the remedy to the harm. For conversion, the remedy isn't a repair cost, it's the full market value of the car. You get a check for what the car was worth.
So if you only take one thing away from this, let it be this. The line between these two torts is simply a matter of degree. The more serious, the more extensive, and a longer lasting the interference, the more likely it is to be conversion instead of just a trespass.
It's pretty incredible when you think about how these centuries-old rules about land and physical objects have adapted to include microscopic particles and floods of digital data. So what's next? As our most valuable property becomes lines of code, digital assets, or even our online identities, how will these fundamental ideas of trespass and conversion continue to stretch and evolve to protect us? That's the big question the courts will be answering for years to come.